Welcome to Criminal Justice 101. A couple of things before we get started. The first is that the entire reason we cover this section is because some of our clients choose to report to law enforcement and move through the justice system. It is not a requirement for any of the clients that we're working with, but we want the advocates to be knowledgeable about the system so that if clients have questions on how to report or what the process looks like, you as their advocate are able to walk them through that. The second thing that I want to emphasize is that this is a very simplistic view of the justice system. So if you've taken any classes or have a more in-depth knowledge, then you can use that along with this information to really be able to explain things to your client. As you get into it, this will make more sense. It's kind of hard to sit here and talk about it this way, but seeing it in action, going to hearings, it'll make a lot of this make a lot more sense. So we're going to go ahead and get started. So we have this section broken down into 3 different mini sections. So we are going to start by looking at the VRA, or the Victim Rights Amendment. So this slide has the legal definition of a victim. So I'm going to give you a minute. Go ahead and read it. All right, so the historical timeline of the VRA. So the VRA started in 1982, and it was started by President Reagan. He created a task force on victims of crime. The entire reason why he did this was because he was shot, and he really quickly realized that the system was set up for the benefit of the defendant rather than the victim. So he started this task force so that they can do some investigation. They came back in 1983 and they established the Office of Victim of Crime, or OVC. In 1984, they present their report and then they enact something called VOCA, or Victims of Crime Act. It becomes law at that point in time. So one important thing that I want to emphasize here is that VOCA is funding for victim services through fines and fees from crimes. So this is not taxpayer money that's being funneled into VOCA, but rather it is money that is being collected from various crimes that are committed and then being provided to victims who have experienced crimes. In 1992, Colorado passed the VRA with 82% of the vote. In 1993, the VRA went into effect then. Between 95 and 97, there was a lot of cleaning up of the legislation. And then from 99 all the way until today, they've been working on strengthening and enhancing the statute. So changes have been made within the last couple of years. So think of VOCA as it's a pot of money. So from those fees and fines that they're collecting at the federal level, that pot is then released to the various states. And then at the state level, they create a competitive grant process. So organizations like Project Hope can apply for money from VOCA to help fund various victim service activities. So a couple of years ago, The federal government, they had a cap on how much money would be released out of the fund each year. They raised that cap, so there was an influx of money for state organizations. So Project Hope, for example, received right around double the amount of money that we had traditionally received from VOCA. All right, so up on the side, you'll find information on what victims of crime need. So go ahead and take a minute to read the slide. Okay, so some things to keep in mind when working with victims. So crime is an active choice by the offender, whereas a criminal is sentenced for a specific amount of time or they're put on probation or parole. Victims don't have that benefit. They're not released from their suffering, from their pain after days, weeks, months, or years. No length of time in prison, no amount of restitution, and no type of punishment is going to bring back the dead or take away the victimization that that person experienced. Victims have already experienced severe pain, and then they receive a secondary pain when the offender's rights takes precedence over their own. So when working with victims, try to imagine yourself as a victim. What are some things that you would want and need? So up on the screen, you will see the legislative declaration for Colorado, Colorado Revised Statute 24-4.2-301. Go ahead and take a minute to read that slide. Okay. So the next 3 slides are rights that are afforded to victims. So I will give you a minute for each slide. Please read the information on it. Here's the second one. And the last one. All right. So now we're going to take a look at what the Colorado Constitution provides. So go ahead and take a minute to read the information on the screen. Okay. So now we're going to take a minute to look at the critical stages. So that was what was referenced in the previous slide. You will find all of the critical stages listed here. So go ahead and take a minute to read the information on the slide. Okay. So one thing to keep in mind is that there are actually written crimes that qualify a person for the VRA. So not every single crime that might have occurred will actually give them the rights of a victim. So if you take a look up on the screen, these are the crimes that qualify for VRA. So you're afforded all of the rights, all of the potential benefits as a victim if you've experienced one of these types of crime. The ones that are colored in pink or that are darker are some of the ones that we specifically see here at the office. So go ahead and take a minute to read the information up on the slide. All right, so now we're going to move into Victim Rights 101. So this is essentially who out of the service provider type organization, so Project Hope, law enforcement, the court, who has obligations under the VRA. So we're going to start with law enforcement. So law enforcement has to provide the victim written information regarding things like community service organizations. So that includes advocate services, counseling, financial support services, or any other type of support services. So when someone is victimized by one of the crimes in the previous slide and they decide to report or law enforcement becomes involved, law enforcement has a victim advocate, if you recall from our initial section at the beginning of the training. And that advocate is responsible for letting that victim know what other services are available to them. So they're going to make those referrals depending on the type of crime. Project Hope only works with domestic violence and sexual assault victims, whereas law enforcement and the advocate at law enforcement is going to be working with victims of all types of crime. So they will refer them to an advocacy service as appropriate. So here, they would only refer to an advocate service if that victim was a domestic violence or sexual assault victim. They are also supposed to let them know about counseling. They should let them know about crime victim compensation, and other resources that may help that victim engage fully in the criminal justice system process. The victim advocate at law enforcement should also be letting them know about protection orders and how to obtain one. They should let them know about the availability of public records for the case. They should be offering them a translator as needed, providing assistance dealing with creditors due to financial setbacks that result from the crime, child care services so that the victim can cooperate with prosecution. They should be providing the victim with contact information for the DA, as well as any officer that's assigned to their case. And finally, they should be keeping the victim informed on if the suspect is in custody, released from custody, as well as any conditions that are given to the suspect regarding that release. The next entity we're going to take a look at is the district attorney. So the district attorney is responsible for informing the victim of the filing of the charges, as well as explaining to the victim what those charges mean. They should be informing the victim of all of the critical stages. So they should be letting the victim know that a hearing is taking place on this date, at this time, at this location. And if that changes for any reason, then they should be contacting the victim again and letting them know about that change. They should be telling the victim who is handling the case, so what specific DA is assigned to the case, as well as the court where the case is going to be heard. So we have usually one victim advocate here in our area that's working with the victims. So that advocate is going to be the one who's doing the communication. The victim is not going to hear directly from the district attorney very often. We have a couple of attorneys here in Gunnison, but we are part of the 7th Judicial District, whose headquarters is located in Montrose. So sometimes attorneys from the Montrose office take on cases in Gunnison. It really just depends. So think of it essentially as law enforcement advocate is there. They come in, they work with the victim, but when charges are filed, that victim is then sort of handed off to the district attorney advocate. So the law enforcement advocate might be involved here or there, but for the most part, they're going to step back, and then the district attorney advocate is going to kind of fill that role. So they are the advocate with the district attorney or the district attorney's office is supposed to be consulting when practical, with the victim on pleas, dismissal, reduction of charges, etc. They should be informing the victim of any pending motion that might delay the prosecution, as well as letting the court know the victim's position on that situation. They are responsible for minimizing the contact between the victim and the suspect before, during, and immediately after processing. So doing that by having a safe space in the courthouse for the victim to wait that's away from the perpetrator. They should be facilitating prompt return of the victim's property. They should be providing the victim with a victim impact statement that is then given to the court. And they should be informing the victim of the function of the various reports that are being released, any information that they can provide the victim about the status of their case or what each of the different critical stages means. The next group that we will look at, or entity that we'll look at, is the court system themselves. So the court is responsible for stating on the record that a victim objects about any motion that may delay the prosecution prior to granting any delay. So essentially, it's all about making sure that if the victim disagrees with how things are handled, that there is a record of that. The court is responsible for determining that a victim is present at all critical stages unless there's a reason why they shouldn't be there. So even though a victim has the right to be present at all of the critical stages, if a victim, for example, is a witness to the case as well, which a lot of times they are, then there may be certain stages that they're not allowed to be present for so that their testimony isn't tainted in any way. So it can get kind of confusing. The court is responsible for allowing the victim to be heard at any proceeding that involves a bond reduction or modification, plea agreement acceptance, sentencing, as well as determining the amount, if any, of restitution that's paid to the victim by the person who's convicted of a crime. They should be letting the victim know about any probation changes as well as any changes in the location of the perpetrator. They should be keeping confidential information about the victim, such as their address, phone number, or place of employment. They should be notifying the victim of the institution in which the person is incarcerated, about any release, any scheduled parole hearing, any escape transfer, that sort of thing. They should be providing the victim with the location and telephone number of probation. They should be notifying the victim of the date of the person's termination from probation supervision. They should be advising the victim of the release of the person in advance of the originally scheduled date of release. They should be letting the victim know about the date of a probation or modification hearing. So if they're revoking probation, if they're modifying it in any way, the victim should be notified. They should be letting the victim know if the defendant dies while in custody. And at the very start of this whole process, they should be keeping the victim informed as to whether the suspect has been taken into custody, if they're going to be released, when they're going to be released, and any conditions that are given to them upon their release. Okay, so skipping down then, we are going to take a look real quickly at Project Hope's obligations. So under the VRA, under the law in Colorado, organizations like Project Hope are not required to provide the victim with any information regarding the VRA. So all of these other entities that we've talked about so far have a legal responsibility to give certain information to the victims. We don't. However, we're good advocates and we want to make sure that our clients are informed, so we educate them about their rights. The final entity that we're going to look at is the victim themselves. So they actually have their own sort of set of responsibilities under the VRA. It's not nearly as intensive as any of the other groups, but the couple of things that they are required to do is to keep the criminal justice system entities, so the advocates, their district attorney, whoever, to keep them informed of any changes in their name, their address, their telephone number. So all of these different groups, law enforcement, district attorney, they're required to be in constant contact with the victim. That's not always in-person contact. It could be letters in the mail. It could be phone calls. In some cases, it might even be text messages or emails. If the victim is not keeping their information up to date with those entities and they attempt to contact them, so the law enforcement advocate has information, they're attempting to call the victim, but they keep getting a message saying that the line has been disconnected, they did their duty. So even though they didn't ever reach the victim, they did what they were required to do under the law. They attempted to contact the victim. Now, you would hope that that advocate would investigate other means to get in touch with the victim. However, there's only so much they can do with the information that's provided. So the victim must keep that up to date if they expect to receive notifications. So we talked about a few slides ago the the rights that a victim was afforded under the law. So there's a difference between pre-sentencing and post-sentencing processes. So if you think about the charges being filed, the trial itself, sentencing, all of that stuff happens before sentencing, right? So at that point in time, those rights are just automatically given to a victim. They're provided. The victim doesn't have to do anything. Anything that happens after sentencing, so after they've become incarcerated, they still legally have all those rights, but it's not a requirement necessarily for people to be contacting them about that. So if a victim wants to continue to be updated on the status of that defendant, on what's going on in that case, then they actually have to submit a written request. It's not complicated. It should only take a few minutes, but if they're not opting in, they may not be receiving notification. So that's something really important to have a conversation with the clients about, and that's something that we as their advocate at Project Hope can do as well. The idea when they first established this was that the whole process was awfully traumatizing for a victim. They may not want to continue to receive information about the case once sentencing has occurred. So the idea was meant to sort of protect the victims, but unfortunately, it just sort of creates a barrier for ones that want to continue to receive information, but don't realize that they need to take this extra step. At one point, the COVA, so the Colorado Organization on Victim Assistance up in Denver, was actually trying to work with the governor to get it so that victims would automatically receive those notifications even after sentencing occurred. But if they decided they didn't want to receive it for some reason, they would be able to write a letter to opt out. I will post information in the comments box below on the status of that. So the final thing we're going to take a look at for this slide is what happens if these different organizations, these different entities have violated a victim's rights. So maybe the law enforcement advocate didn't communicate the information they were supposed to a victim. So Colorado state law provides victims the opportunity to enforce compliance by notifying the Victim Compensation and Assistance Coordinating Committee. So this is a committee that's located in Denver. So it's recommended that the victim first seeks compliance at the local level. So if the law enforcement advocate messed up, then the initial step is supposed to be to talk to the advocate, but to continue to move up the chain of command. So go to the supervisor, etc. So the victim is encouraged to seek assistance from a victim advocate or a counselor. So at that point, Project Hope would assist the victim with this process. The victim is encouraged to seek assistance from elected officials or the head of the agency if they feel like their complaint is not being properly responded to. The contacts may be just a verbal interaction with the victim advocate or their supervisor, or it could be a written. Written's encouraged just because there's a paper trail at that point in time. And they definitely need to be keeping accurate records. If that just isn't working out for them and they need to go to the next step, there is a form, an official complaint that they can file and send to that organization in Denver for review. The one thing to point out here is that the review committee themselves don't really have a lot of teeth in this circumstance. So if the law enforcement advocate messed up and the victim confronted them and the problem wasn't solved, the victim could file that formal complaint and there could be an investigation. However, at the end of the investigation, all that committee can really do is make recommendations. So they might recommend that the law enforcement advocate goes through training on how to provide these rights to a victim. However, there's not really a punishment per se. That being said, if for some reason another complaint is filed, or the police department maybe didn't respond to the committee's recommendation in a way that was felt to be appropriate, at that point, the information could go to the governor's office, who has a little bit more teeth in the situation, and they could threaten the police department with pulling their funding if they didn't get things taken care of. So it doesn't fix the fact that the victim didn't receive the rights, but hopefully would help make sure that future victims were informed of their rights properly. Okay, so that was the first section of this training. So now we're moving into the second section, which is focused specifically on the criminal justice system. Again, please keep in mind, basic overview. All right, so up on the screen, you will see a victim notification flowchart. So as I'm talking, please take a look at the information and see if you can sort of follow along. So in order to be considered a victim, they have to be an actual person. What this essentially means is that a business cannot qualify for the VRA. It has to be an actual person. It's also important to look at the charges in the case. The charges being filed may disqualify someone from being a victim. So unfortunately, the victim of a crime has no say over what charges are being filed. That is completely the district attorney's decision. And so sometimes the charges that they're filing against a defendant are not ones that will ensure that a victim is actually receiving rights under the VRA. So there's also a difference between a right and a want. Victims are going to want a lot of things throughout this entire process, but they're only going to be provided what's considered to be a right under the VRA. So remember, again, a few slides ago, I talked about how the rights prior to sentencing are automatic, but after sentencing, the victim has to request them. So if you look at the flow chart up on the screen, so a victim, assuming that they're wanting to report to law enforcement, they would then go ahead and make a report. Throughout the entire process, they should be treated with fairness, dignity, and respect, notified of all of the rights as a victim, informed of community resources, and be provided information on what to do if they're being intimidated or harassed by the defendants. So then there's two sort of courses that a case could take. The first one is if there is no suspect apprehended. So for this one, maybe they didn't know who the person was or they weren't able to find them. So they're not going to receive quite as many rights because the criminal justice system just doesn't know who victimized them. So they should still be notifying the victim of the status of their case. They should be providing them information on civil remedies that they might be able to try, and they should be releasing any property to the victim that was confiscated. In the case where a suspect is apprehended, the situation changes slightly, so the victim should be receiving information on the charges that are filed against that person. They should be provided information on the status of the accused, so are they in custody, have they been released, what are the conditions, etc. They'll be given information on how to contact the district attorney's office to ask questions, and then again at the end, they should receive property that was confiscated. So I realize the title's cut off, but this slide's titled VRA Rights. So these are looking at some additional rights that are provided to the victim, as well as things that the VRA does not cover. So go ahead and take a moment to read the information up on the slide. So the right-hand column that looks at the things that the VRA does not cover. So essentially think of these to some degree. So things like the manner in which the case is investigated, decision as to whether or not charges are filed. So those are things that a victim might want to have a say in, but unfortunately it's not a right that's given to them. The DA should be letting them know what the DA's decision is, and the victim will have an opportunity to say that they disagree, but that doesn't mean that anything's going to be done with that disagreement. So the first bullet point is just talking about cases that are filed in municipal court. So sometimes in smaller areas, in various communities, DV cases might go through municipal court. So at that point in time, they may not be receiving VRA rights. Okay, so this next slide is taking a look at the criminal justice system and the process. So again, this is sort of a simplification of the whole thing, but even simplified, you can see how complicated the entire process is. So feel free to look at the slide, but I do have some verbal information to give you. So this we refer to as the things that you didn't learn from Law and Order. So think about any sort of crime show that you've seen on TV. We're going to go into depth of sort of the differences of real life criminal justice system versus TV criminal justice system. So again, reiterating that the various entities that are involved in this process have different responsibilities. So just a summary, or in a nutshell, law enforcement is responsible for the investigation of the case and for informing the victim about the rights as a victim. The district attorney is responsible for explaining the process to the victim, providing support and assistance, answering questions, dispensing information, assuring that the victim's input is considered, being a main point of contact for the victim, and providing a support role. System advocates, so that's your law enforcement and your district attorney advocate, are required to inform the victim about follow-up support for the victim themselves as well as immediate family members. So for domestic violence and sexual assault cases, that would be Project Hope. They should be notifying the victim about any services available for children, elderly, or disabled victims, referring for counseling services, providing them information about transportation as well as household assistance, interpretation services, and child care services. Okay, so now we're going to take a look at the arrest and charges process here. So if you start on the left-hand side of the screen and you're kind of working your way over, the procedure for arresting and charging is going to differ based on the defendant's age as well as the nature of the offense. So essentially a misdemeanor versus a felony. After investigating, law enforcement may proceed with an immediate arrest, or in some cases they may seek an arrest warrant. The victim may be asked to identify the attacker in a lineup, but not always. However, the one thing that does stay consistent is the suspect will be brought before a judge, and they're going to be informed on the charges against them, their right to an attorney, the right to remain silent, and then the date of the preliminary hearing. At that point, the suspect may be released on bail, but that's completely up to the judge. Oftentimes a no contact order is issued, so essentially a protection order to keep the defendant from harassing or injuring the victim. There are penalties if that no contact order is violated. As far as the investigation piece, remember, we're on the law enforcement side of things, so the investigation is assigned to a detective. In most counties, the victim is contacted by the police department or the district attorney advocate. So they may not be speaking very directly to the detective or to the district attorney themselves, but rather to the advocates that are involved in the case. The advocate is responsible for informing the victim of their rights, and they may help the victim acquire things like a protection order or crime victim compensation. So once the law enforcement is done with their investigation, there's a few different things that can sort of happen. So they could decide that there's not enough information for anything to be done, and then it just sort of goes away. The process stops at that point in time. Or law enforcement might decide that, yes, there's enough to determine that a crime most likely occurred, and then they provide that information to the district attorney's office. Once it's handed over to the district attorney, it's still not a guarantee that a case is going to be formed or that charges are going to be filed. The district attorney will sort of do their own investigation, and then they'll decide from there. So there's, again, a possibility that stuff could be dropped and that could be the end of it, or charges will be filed. And then at that point, it'll either be the felony or the misdemeanor charges. So you can see the various branches on the screen in front of you that sort of determine the path that will be followed based on those charges. So the criminal charges are started by the prosecuting attorney, and they're filing on the victim's behalf. So the victim is actually considered to be a witness for the state. So when these cases end up in the hands of the district attorney, it's no longer that victim versus that defendant. It is actually the state of Colorado versus that defendant, and the victim just becomes a witness. The biggest downside for this is that the victim is no longer in charge of the situation. The district attorney is 100% in control. These crimes are considered to be crimes against society as a whole. That's the reason why it becomes the state of Colorado versus the defendant. So the district attorney is the attorney for the state, not for the victim. They're making all critical decisions about the case, although they are required to consult with the victim. But again, just because the victim's disagreeing doesn't mean that the attorney has to adhere to those disagreements. The victim is able to obtain their own attorney. That attorney is not going to be involved in this process, but the victim could potentially start a civil suit. And in those cases, the victim is going to have a lot more control over what's occurring. The district attorney doesn't want to be a witness in their own case, so the information that's shared with them from the victim is passed to the defense team, and any information from the attorney is typically passed through the advocate. So that just goes back to the comment that I made earlier, that the district attorney has little to no contact with the victim directly. The district attorney and the victim advocate are assigned by the DA's office. The victim doesn't get a choice who they get. So if they really have a problem, they could technically complain, but the likelihood of a new attorney or a new victim advocate being assigned to their case is pretty slim. Okay, so now we're going to kind of walk through the process if charges have been filed. So we're going to start at our preliminary hearing. So the purpose of this hearing is to determine if there is enough evidence for a judge to decide that the crime was probably committed and that the defendant probably committed the crime. If probable cause is determined, the case will move forward. But the case could also be dismissed at this point in time. Witnesses are called during the preliminary hearing, and the defense can cross-examine the witness. The defendant also has the right to be at the hearing, just like the victim. So the next little piece that we're going to look at is the grand jury. This doesn't happen in every circumstance or in every court, so it really just depends. But the grand jury is a group of 16 people that are selected for jury duty. They meet and decide whether there's enough evidence to make a formal charge against the defendant. Again, it's not used in all jurisdictions, and it's a different process than open court. The prosecuting attorney will call the grand jury to hear evidence in a case. They'll hear the evidence in private, and then the grand jury can issue an indictment against the defendant, and then the case would move forward. Next, we're going to talk about advisement. So prior to arrest, a wanted person is referred to as the suspect, but once formal charges have been filed, they're then referred to as the defendant. Following the arrest, the defendant must be taken without unnecessary delay to be advised by a judge. Bond may be set at this time. The appearance often occurs on the next business day following the arrest. Depending on the crime and severity, the defendant may post bond and be released. Formal charges must be filed no later than 72 hours following the arrest, at least generally speaking. The second advisement is then set within 30 days of the charges being filed. An arraignment is conducted to inform of the charges, and a plea is entered. There are several different types of pleas. You've got guilty, not guilty, no contest, and not guilty due to a mental illness. So as far as plea negotiations, typically people view a plea agreement as a bad thing. So, the case didn't go to trial, they reached a plea agreement instead. That means that as a victim, I'm not believed. They don't think that something happened to me, or that individual is getting off easier than they would have if the case would have gone to trial. That's actually not the case. Plea agreements are not always a bad thing, and they certainly don't mean that the victim was not believed. A plea agreement guarantees a consequence, whereas trial can be a roll of the dice. The case could have gone to trial and the charges could have been dismissed, or the jury could have found the individual not guilty, in which case the victim receives no justice and the defendant receives no punishment. A victim does get a voice with pleas, but not a veto. So if they don't agree, they can certainly voice that to the district attorney. They could even voice that to the judge themselves. It's ultimately up to the judge on whether or not that agreement will be accepted. Remember that not all cases go to trial. If they did, the court system would be even more bogged down than it currently is. On average, in our area, it takes 2 to 3 years for a sexual assault case to move through the system, which is an extremely long time for a victim. So with the plea agreement, a defendant is convicted and punished without having to go to trial, which may be beneficial to all parties. It's not entered into lightly, and all information must be weighed before offering pleas to a defendant. The district attorney's role is to consult with the victim, and they should be considering the nature of the crime, the type and amount of evidence, and the defendant's record. After a plea is agreed on, it is then presented to the judge, but the judge gets the final say. So I've seen a court hearing where the district attorney reached a plea agreement, dropped a lot of the charges from felonies down to misdemeanors. The victim was extremely upset about the situation. They went to court. They stood up in front of the judge and said that they didn't agree. The judge did decide to side with the district attorney, but the judge at that time could have also told the district attorney that they needed to go back and they needed to come up with a new agreement. So it's completely up to the judge. Sentencing usually occurs at a later date. And the time frame for that can be kind of skewed depending on circumstances. Something that happens pretty continuously in this whole process are delays and continuances. So the judge may allow certain delays when asked. If a delay is granted, the district attorney's advocate must try to notify the victim in advance. If the victim objects, the judge has to take it into consideration when deciding if they're going to allow the delay or the continuance. And that objection is kept in court record. Motions are what we're going to look at next. So prior to trial, the prosecutor and defense may file motions and request a hearing for the court to decide the issues contained in the motion. Motions allow parties to communicate directly with the court about matters of law. They often address evidence, but motions can also address the victim's personal history or history of contact with the defendant. If the case makes it to trial, both the prosecutor and the defense will be allowed to question potential jurors to try to pick a fair and impartial jury. The district attorney goes first when it's the actual time for the trial. The district attorney goes first with an opening statement. They call witnesses who can then be cross-examined by the defense team, and then they rest their case. The defense is next. They present evidence if they choose to. In some cases, the defendant may testify. The defense team can call witnesses, which then can be cross-examined. The DA can also call rebuttal witnesses at that point if they choose to. The judge will give instructions to the jury. Both the defense and the DA will have closing arguments, and then the jury will deliberate. In terms of sentencing, the judge will impose a penalty on the defendant. There are min and max sentencing guidelines that are used, and that's how the judge makes their determination. The victim will be given an opportunity to write something called a victim impact statement, which can then be read at court prior to sentencing. The nice thing about the victim impact statement is that the trial itself focuses so much on evidence, and that's really the only thing they're interested in. But in the victim impact statement, the victim can talk about the emotional toll that the violence had on them, or talk about things that are less concrete and really convey how the crime impacted their lives. That is taken into consideration when the judge does sentencing. It can be read by the victim, it could be read by a family member or an advocate on behalf of the victim, or it can be provided to the judge in writing and they can read it themselves. We're going to look at restitution then, which is kind of the end of this initial front part of the process. So the judge may order the defendant to pay restitution to the victim. It really depends on the circumstances. Really only happens if the victim experienced damage to property or if there were medical expenses as a result of the crime. Again, the victim impact statement will help determine if restitution is appropriate or not. They can track losses in that, but the judge is the one who ultimately decides the amount. The defendant may not be able to pay restitution while they're in custody, but they should while they're on probation. Should being the operative word here, it's probably not likely to happen. I mentioned a while back about civil suits, so a victim could always hire their own attorney and take out a civil suit. So there are some benefits for this. The victim is in complete control over the situation. They hire the attorney, they get the final say in everything because that attorney is working for them. The other benefit is that there's not the same burden of proof in a civil case as there is in a criminal case. So they may be more likely to see consequences in a civil case compared to the criminal case. The defendant may be required to pay restitution to the victim as a result of winning the civil or losing the civil case. Punitive damages may also be awarded. Victim could bring a suit against a person or a business for failing to provide reasonable security when, for example, a sexual assault occurred. So it also gives them a little bit more flexibility on who they can take to court. Okay, so we are going to move on. The next several slides are a glossary of criminal justice terms. So I'm going to give you a minute per slide. Go ahead and read the information up on the screen. Okay, continued. Next slide. And our final one. Okay, so we're going to end this little mini section of Criminal Justice 101 with talk about courtroom layout and etiquette. So up on the screen, you will see an example of how a courtroom may be laid out. If I'm remembering correctly, the Gunnison courtroom is opposite of what the picture is showing. So in very simplistic terms, during the trial, the prosecutor sits closest to the jury box, although during hearings, pre-sentencing, preliminary hearings, those sort of things, it may be opposite. Sometimes they use the jury box to house various defendants that are being seen by the judge that day. Adjacent to the bench is the witness stand, as well as a desk for a clerk or court reporter. As far as etiquette, and if you're attending a hearing or trial, so stand when the judge or jury enters or exits. Make sure that you turn your cell phone off, so not just on silent, or not just on vibrate, excuse me. You need to completely silence it or turn it off altogether. Don't bring any food or gum into the courtroom. Water may be okay, so you might be able to bring a water bottle, but you need to check the signs to make sure that it's all right. A victim won't need to bring one. They will have a water pitcher and cups on the table up front for them. Do not wear hats to the courtroom. And in terms of attire, it's a step up from what you wear day to day here at the office. So think about the clothes that you wear, adhering to our dress code, and just take it to the next step up if you're going to attend a court hearing. Make sure that you're keeping any emotional reactions to a minimum. So if you think of like your Judge Judy or some of those other TV courtroom shows, there's a lot of people hollering and talking over one another, rolling their eyes, that sort of thing. So that is not appropriate inside of the courtroom setting. If this is something that you struggle with, maybe bring a small notebook that you could discreetly maybe put up in front of your face, or you could even look down to try to get emotions under control. This is something that you might want to talk to the victim about a little bit as well. It can be extremely difficult, but for them and any of their friends, that sort of thing, you don't want them to create an uproar that's then going to make the judge force them to leave the courtroom. No talking or whispering. That's another way that the notebook I mentioned before could come in handy. If you really feel like you need to communicate to the victim or to their friends or family, if you're sitting with them, or maybe you go up with a few other advocates, you could write a note and discreetly pass it to the other person, but really, as much as possible, no talking. Be mindful of what side of the courtroom to sit on. So you want to make sure that you're always sitting in the rows behind the prosecution table, not behind the defense table. Make sure you arrive early. So if you're not there 15 minutes early, then you're late and you shouldn't go. The last thing you want to do is walk in and cause a disruption. Okay. So our final mini section is looking at protection orders. So there are a few different types of protection orders. The first one that we're going to take a look at is our emergency protection order. So any county or district court shall have the authority to enter an emergency protection order pursuant to the information that I'm going to list to you right now. So an emergency protection order is issued and often will restrain a party from contacting, harassing, injuring, intimidating, threatening, molesting, touching, stalking, sexually assaulting, or abusing any other party, a minor child of either of the parties, or a minor child who is in danger in the reasonably foreseeable future of being a victim. It excludes a defendant from the family home or from the home of another party upon showing that physical or emotional harm would otherwise result. It may award temporary care and control of a minor child to a victim in this circumstance. It may prevent the suspect or the defendant from contacting that child at school, work, or any other location they may be found in. It will restrain that suspect or defendant from molesting, injuring, killing, taking, transferring, encumbering, concealing, disposing of, or threatening harm to an animal that's owned, possessed, leased, or kept by the victim. So essentially what this is saying is not only is the victim able to be protected under a protection order, but a child and an animal belonging to the victim can also be listed as sort of a protected party in a protection order. Okay. So the next type that we're going to look at is the mandatory protection order. So again, these are specifically issued in cases where domestic violence, sexual assault, stalking, child abuse are occurring. So just like the emergency protection order, it's protecting a victim from being harassed or injured by a suspect. It's protecting the child, and it's protecting any animal that's involved in the situation as well. So some differences for a mandatory protection order compared to an emergency protection order is that a mandatory protection order may be modified at the request of the victim. So it's issued by the court, but maybe the victim decides that for some reason they need to be in contact with the suspect, so they can actually petition the court to modify. The judge does get the final say, so they may deny the request, but the victim does have the ability to ask. The protection order goes into effect immediately, and it remains in place even when modified throughout the entire case. So if a crime happens, a mandatory protection order is issued by the judge throughout that investigation process that law enforcement is doing, up to when it is handed over to the district attorney's office, and all the way up to sentencing, that protection order exists. If at any time if at any time charges are dropped or the case is dismissed, that protection order goes away. Once sentencing has occurred, that protection order goes away. The abuser is not allowed to have any contact with the victim at all, and this includes third-party contact. So when the MPO is issued, they're not allowed to have their brother-in-law or their brother, contact the victim, or a friend follow the victim. So any of that will be considered a violation of the protection order, and that suspect or defendant will then face consequences. Going back to the victim modifying, so if you see this a lot of times in cases where there's a child involved, if the victim wants to modify the protection order so that they can communicate with the suspect or defendant regarding the child's care, they can request it. It's recommended that they limit the type of contact, however. So rather than opening it up to any contact from the suspect or the defendant, maybe just text communication or just email communication. Written communication is best because then it leaves sort of a paper trail. So if at any point the defendant threatens the victim, they have a text message or an email that sort of proves that can then get taken back to the judge. If it's a verbal communication between the victim and the defendant, it turns into a he said, she said situation, and the law enforcement may not be able to do anything to the defendant as a result of that. Okay. Once the mandatory protection order is issued, the defendant is allowed to return to the shared home one time to collect their personal belongings. It's with a police escort. And then they are not allowed to turn off any utilities, shut off the phone, or take the car if there are kids in the home. So there are some further protection for the victims so that the defendant can't start punishing them for reporting. If the abuser owns the home, or if they are the ones who are renting the home and the victim's name is not on the lease, then the victim has 5 days and then they have to leave the premises. The abuser is not allowed to have possession of any guns or bullets. There's a affidavit that they are issued by the court that they have to complete, saying that they relinquished control of any guns or ammunition that they own to another party. Unfortunately, there's not a lot of repercussions for this. So it is just sort of based off on good faith, right? So maybe the victim knows that the defendant has guns and they mention that to the judge, or the judge asks, but the victim may not know how many or what type. So the judge will issue this affidavit, and then the perpetrator is expected to relinquish, but all they have to do is sign this piece of paper and say that they did. There's not really any sort of further proof. There's also an issue of who they need to relinquish it to. Law enforcement won't take possession of them, at least here in Gunnison and other areas they might. But it could be difficult for the perpetrator to get rid of those weapons. And then again, there's no way to prove that they got rid of any or all of those. But they are supposed to do that within 24 hours. So the third bullet point is looking at our civil protection order. So a civil protection order is different compared to an emergency or mandatory, in that for a civil protection order, the victim initiates the process. So an emergency or a mandatory protection order, the court or law enforcement is the one who does the issuing. For a civil protection order, a victim actually has to fill out an application and petition the court themselves. There's no fee for victims of domestic violence or sexual assault, so they shouldn't be charged a cost for this. It is a two-step process. So the first step is that they complete the application, which we have blank copies of here at the office and can assist with. But they complete the application and they turn it in. It's usually a same-day situation. So they'll go over to the courthouse, they'll talk to the clerk, they'll say that they've got a request for a civil protection order. Oftentimes it's immediate, but sometimes it might be a couple-hour delay. But the victim will sit down with the judge pretty immediately, and the judge will hear the case. So it's just the victim. If they bring an advocate with them or another support system, that person will be there as well. And then the judge and a clerk. The judge will read over the application. They'll ask questions. The victim can give them some more information about what's occurring at that time. And then the judge will decide if they're going to proceed. I've not really ever seen a judge deny the initial step. So the initial step is to award a temporary protection order. So this is typically a 2-week protection order. While they're sitting there, the judge will actually set the date for the hearing for that protection order to go from temporary to permanent. So the victim will be made aware of that on the spot. The judge will sign the protection order, copies will be made. The victim is given a copy that they then have to take over to the sheriff's office to be served to the perpetrator. So some things that the victim's going to need in order to get that temporary protection order, they're going to need an address for the abuser. So a place where the abuser can be served with the paperwork. This does not have to be a home address, it could be a work address. But if they don't know where the perpetrator is, it's almost impossible to serve them with the paperwork. So a protection order does not go into effect until that perpetrator's been served. They need to have the abuser's full legal name. On the paperwork, there is a spot for the victim to put their address and contact information. The victim should not put their address on the paperwork. The victim wants to be as specific as possible, but at the same time not give too much information. The abuser, as well as their attorney, will have access to the paperwork. They can always go into more detail when they're before the judge. So enough detail to make the judge see that there's something going on, but provide most of that verbal. If the victim has a child, then there is a separate affidavit for children that needs to be completed as well. For the hearing, for the protection order to go from a temporary to a permanent, it is advisable that the victim obtains a lawyer. 14 days isn't a lot of time, and sometimes it's a little bit less or a little bit more depending on scheduling. But we as Project Hope can work with the victim to get them some legal assistance going into that hearing. It'll really be beneficial for them to have an attorney. The judge will want to know if the victim plans on filing for divorce if they're married. So that's something to just prepare the victim for. They will be asked that question. Make sure that the victim understands that the protection order could be denied. So the temporary protection order could be denied. When they go to the hearing for the permanent protection order, that could be denied. It's not a guarantee. So also the victim needs to be aware of the fact that the defendant will be present at the hearing. They have the right to be there to argue against the protection order. Sometimes if the defendant doesn't show up for the hearing, the protection order will just automatically be made a permanent protection order. If the victim is going to be filing for divorce, if there's any sort of custody issues, sometimes a temporary one might be extended out so that those other matters can be determined before a permanent protection order is in place. If the judge decides to award the victim a permanent protection order, the offender is able to petition the court to have that permanent order modified, but they have to wait 2 years. There are a lot of hoops that the offender will need to jump through, including a background check in order to even be considered for modification. If the modification is denied, they have to wait an additional 2 years to try again. The victim is notified each time that a request is made for the protection order to be modified. So the victim is well aware of it, they get to attend the hearing, and they get to argue against any modification. So whereas the offender has to wait 2 years before requesting and has to wait an additional 2 years each time, the victim is actually able to request a modification at any time. Children for these protection orders are only covered for 1 year, and then the case needs to go to family court so that parenting time can be determined. This is only applicable if it is a child of both parents involved, either biological or adopted. So if the child is only the victim's child and the defendant has no sort of custody rights, then that child could be added to the permanent protection order as well. Minors don't get much say over being a protected person, and safety planning is going to be the best way to make a client safe. A protection order is just a piece of paper, so although it's a good thing for a victim to have and could potentially guarantee consequences for the defendant if they violate that protection order, it isn't going to keep a victim safe. So any of our clients that are filing for a protection order should also be completing a written safety plan with their advocates. So now we're going to take a moment to look at best practices for advocates that are working with victims. So again, these are for clients that come in, either current or new ones that were referred over who are interested in filing for a protection order. So some general information for you as an advocate to know and to communicate to them. So consider the venue when filing. Protection orders can be filed in the location each individual lives or works if they're different. So if the victim lives here in Gunnison, but the perpetrator lives in Montrose, They could actually file the protection order in Montrose instead of in Gunnison. The benefit of doing that is if the abuser does not know that the victim is in Gunnison, you're not bringing them to the victim. So again, the defendant has the right to be present at that hearing, so it may just help them to pinpoint the victim easier. Remember, we talked about in the Domestic Violence 101 section, the last few slides that discuss stalking. The same thing can be said with stalking. Oftentimes, if a victim is going to get a protection order against a stalker, it's best to file that protection order in a different area if possible. Now, if both the victim and the perpetrator live and work in the same community, that's not really going to be an option. Again, the victim wants to be specific on the form, but not give too much detail. Safety planning needs to be part of the process because the protection order is just a piece of paper. And then the victim cannot violate the protection order, only the offender can. So the offender is prohibited from contacting the victim, but the victim is not prohibited from contacting the offender. That being said, if the offender is engaging with the victim, they're going to be in trouble. And it certainly isn't advisable for the victim to be contacting the offender. However, the victim can't get in trouble in those circumstances. So looking at care and control, so this is for kiddos that are involved in the situation. So sole decision making for dependents can last up to 1 year if they're listed on the protection order. This is best for victims because it prevents them from having to go to court multiple times. Any orders that are issued in dissolution of marriage or allocation of parental responsibilities will be tied into the protection order. As far as the parenting plan, so the victim is going to need to be specific about what they want. They're going to need to figure out how much contact they want with the perpetrator during this process. So if contact is necessary, it should really be limited to email or text, and should specify what the contact is about to allow the victim to have proof if the order is violated. So not only saying that the defendant can only contact the victim via text, but also that they can only speak to the victim about the care of the child. So it's really tightening that loophole as much as possible. As an advocate, one thing to have a conversation with a victim or a client about is the exchange of the child. So when the child is going from one parent to the other parent, you need to be thinking safety. So doing this in a public location, the Department of Health and Human Services can certainly facilitate that. CASA might be another option, maybe doing it at the police station, but they don't want to be driving that child to the perpetrator's house or meeting that perpetrator in a place where other people aren't around to intervene if it becomes necessary. Okay, so we talked about another thing that you could do as their advocate is help the client to make a list of concerns that should be addressed in the protection order application as well as the hearings with the judge. Make sure that the victim thinks about any dependents or animals that should be listed on the protection order. Talk to them about any guns that they're aware that the perpetrator owns. Create that safety plan and just determine lethality factors for the victim. There are certain things, drug and alcohol use, gun ownership, that increase the likelihood that a victim could be killed as a result of leaving this abuser or filing a protection order against the abuser. Okay, so I think I made a slight mistake in saying that we only had one more little mini section. This is the last section for the 101 training that we're doing. So we're going to spend a few minutes looking at crime victim compensation, or CVC. So the purpose of CVC, it was passed in 1981 by the Colorado legislature, and it covers crimes in the jurisdiction that the crime occurred in. The purpose is to decrease the financial burden of a victim. It is limited to around $20,000, although that's on the high side. Again, just like for VOCA, tax money is not used. So VOCA is a collection of the fines from federal cases. CVC is from local jurisdiction cases. So offenders are paying in parking tickets, speeding tickets, a variety of other things. That money is collected and placed into this pool that's then issued to victims. It has to be a VRA crime in order for a victim to be able to receive compensation. So there is a CVC board, and they're the ones that are making the determination. The specific function is to accept and evaluate claims requesting payment of bills incurred by a victim or due to a loss of income or economic support as a result of a VRA crime. The CVC is considered to be a payer of last resort. So the board has to ensure that a victim has used all other resources before applying to the board for compensation benefits. Benefits are rarely paid directly to a victim, but instead to whomever the funds are due to. So for example, counseling. If a victim is needing counseling as a result of the victimization that they experienced, then the CVC, if approved, would pay the counselor directly. So now we're going to look at things that are or are not covered. So things that CVC will cover. So they'll cover reasonable medical and hospital expenses, as well as expenses for dentures, eyeglasses, hearing aids, or other medically necessary devices. They'll cover loss of earning, outpatient care, homemaker and home health services, burial expenses, loss of support to dependents, mental health counseling, and losses from property damage that include repair or replacement of windows, doors, and locks, or other security devices that were damaged during the crime. Payment of the deductible amount of residential insurance policy, or recovery on property damage not to exceed $250 for each crime. Losses that CVC will not cover: aggregate property damage that's less than $25, pain and suffering, property damage other than residential property damage, or aggregate damages to the victim or dependents that exceed $10,000. So that's the average. It could go up to $15,000 or $20,000 in catastrophic incidences. So anything that's not covered by CVC can be turned over to restitution with the victim's permission. As far as eligibility, so the crime must be one to which the victim suffers residential property damage, economic loss, injury, or death as a result of the crime perpetrated or attempted. So it doesn't need to be carried out. If the crime is attempted, it still could qualify. The person who's claiming the compensation has to be a victim or a dependent of a victim of a crime that happened after July 1st of 1982. The police must be notified within 72 hours after the crime, or a good cause has to exist for the victim not reporting within 72 hours. So a victim is not going to qualify for CVC unless they're choosing to report. The victim has to not just report, but cooperate fully with law enforcement. And the CVC board does follow up with the local law enforcement office to ensure that that's the case. A defendant does not need to be arrested or charged. So all they need to do is report and cooperate. But if things are dismissed, a victim, maybe charges are dropped against a perpetrator, that's fine. They could still qualify. The victim only has up to a year to actually file for CVC. So they need to report to law enforcement within 72 hours, but they have up to 1 year to actually complete the form and receive money from CVC. Another piece for the eligibility requirement is that a victim cannot request compensation for an injury that was the result of a crime that they were committing. So let me explain that in case that wasn't clear. So if me and my friend and I decide that we're going to rob a house. We rob the house, and on the way to escape, I trip and fall and I break my leg. I am not a victim. I was committing a crime and I was injured. I'm not allowed to ask for CVC. I'm not a victim. So I hope that makes it clear. So as far as the application process, so they need to complete the application, which again we have blank copies of here at the office, and they have to send that packet to the CVC office. We can send it on their behalf if we have a signed release, or we can give them the information to send it themselves. If they have accumulated any bills, then those should be included in the application packet. So for this, it could be they were sexually assaulted and went to the emergency room to get a rape kit, or had some other sort of examination by a doctor, and maybe they have a statement from the hospital or from that doctor. So they could include those in their packet. The CVC office compiles law enforcement reports as well as verifies bills and treatments. So CVC is doing a lot of investigating, and then they'll contact the victim if they have any questions or need clarification about anything. CVC staff will then compile a board packet with the completed application and reports, and then they provide it to the CVC board. The board will then meet and review the information. The deadline for our CVC board is the last Friday of the month. The board only meets once a month. For a sexual assault case or some of the other cases that a victim might be requesting funds for, it may take more than one meeting for that to be determined. So it may actually take several months for the CVC board to decide if they're going to approve or deny it. The office will send a letter then letting the victim know if they were approved or denied, and they'll also start to issue payments. They will also provide the victim with a survey that they can complete, and then the file will be closed. So in some cases, they may decide to award an emergency award within the first 72 hours. So the CVC administrators, the staff, review the application, and if they decide that something like counseling, for example, is necessary because the experience was just so traumatic, or it was such a bad situation that the victim just really needs to get into counseling now, even though the board hasn't had a chance to review the application, then they can approve a few sessions. It's typically only about 4, but those sessions could be immediately provided to the victim. They can't just see any counselor. They have an approved list of counselors, so the client will have to pick somebody off of that list, although it is easy as a counselor to get on the list. After the application is reviewed by the board, the victim may be able to receive additional sessions, but the counselor will have to submit a treatment plan to CVC. They may also award emergency funds to replace doors, locks, or windows that were damaged as a result of the crime, again, because that's a safety issue for those things to not be working. Our CVC board specifically likes to award money for counseling. It's fairly easy for victims to get that money. We've also not had any victims that have applied for CVC not get some funding. I had a client that I worked with years ago who went through a pretty traumatic sexual assault case. she ended up with a lot of bills from the hospital and follow-up doctor visits, thousands of dollars. And she would bring those bills in to me, and I would help to submit them to CVC, and that was covered by CVC. So it's extremely helpful for victims. Okay, so that was the Criminal Justice System 101 in a nutshell. I realize that that was a ton of information, but at this time, go ahead and work on the quiz for this section. Remember, there's that last question that you can list out any things that you need clarification on, and a staff member will get back to you to clarify. But thank you so much for listening. We appreciate it.